So it's being recorded now. So chapter 9 is more about contracts. So we're going to talk about contractual capacity, legality, voluntary consent, and finally about the writing requirements, right? So talking about minors, when minors enter contracts, minors can legally enter into a contract, as long as it's not a contract that is illegal for minors, such as contract to purchase alcohol or something like that, right? Or marriage under 18 is usually illegal, right? Other than that, minors are allowed to enter into a contract, but the difference is minors can void the contract. They can say, yeah, I entered into this contract, but I really don't want to do this anymore. I didn't understand what I was getting into. Or yeah, I did understand what I got into, but I can't really afford this anymore, and things like that, right? However, often what happens is that parent will also sign for the contract. So if a minor enters a gym membership, the parent usually has to sign the contract as well. So the minor can no longer get out of, or the minor can technically get out of the contract, but because the parent also signed it, and because the parent is an adult, the parent has no right to void the contract anymore. So the parent would have to continue paying if the minor stops paying, right? There are actually some exceptions. I'm trying to think of an exception. Of course, if you have already consumed something that you bought, let's say you bought something or you already received it and consumed it, right? Let's say, and you can't return it. In that case, you can say, yeah, I bought this, I consumed it, but I don't want to pay. Justin?
What if a child emancipates from their parents?
If a child is emancipated, yes, they could be held liable to pay the contract. And in that case, they can also, like, for example, a rental contract, renting an apartment, right? In that case, they have to, right? So emancipated minors are different, right? And when at one point the minor will turn 18, and at that point the minor can decide, will they ratify the contract, accept it as it is, or will they disaffirm it after they turn 18, right? If they accept it, they can now no longer void it once they have ratified it. Parents, again, are liable if because of the fact that most businesses will ask a parent to sign the contract as well. Intoxicated persons can, when they enter into a contract, it could be voidable or valid. When it's valid, it is enforceable. It really depends on how intoxicated the person was. If the person was intoxicated enough to not understand the terms, they can void the contract, but they have to prove it. They can't just say, oh, I was drunk. I didn't know what I was getting into because I was too drunk at that time. That doesn't work, right? If they weren't drunk, if you just had a glass of wine or a beer, you're probably likely to understand the terms, right? How can somebody prove that they were drunk? Well, they signed a contract. Diego?
Social media.
Social media.
Some people post weird things when they're drunk.
It's friends.
Maybe with friends, yeah. Maybe some friends were the witnesses, basically. Witnesses, yeah. There was a case in the textbook, and I don't remember if I came up here. But two friends, they've been friends for a long time. They live in some kind of town. And one of them owns some kind of farmhouse. And his friend always wanted to buy the farmhouse, but this guy never wanted to sell his farmhouse. So they are out drinking at a tavern. And this happened ages ago. It's an old case, right? And, they were drinking and frolicking and having fun and stuff like that. And then they talk about the farmhouse again. And the guy who wants to buy it said, I really want to buy it. And then he said, okay, I'll sell it for you. And they wrote it on a napkin or on a receipt or something like that. It wasn't a formal contract or anything, with a price tag, and they signed it. And the next day the seller said, no, I didn't mean to do that. I was just kidding. I was drunk. But his wife was there and she signed, and he asked his wife to sign as well. And his wife signed too. And he couldn't prove that he was drunk enough. So he had to sell the house. Yeah. So be careful what you do when you're drunk. Don't get married when you're drunk. All right. Mentally incompetent persons, the contract, again, depending on when it was, in this case, it depends on the time it was signed. If it was signed while the person was still mentally competent, it can be enforced, even if the person becomes incompetent afterwards. However, if it's a service contract and the formally competent person becomes formally now incompetent, and that person was the one performing a job, now they can no longer perform the job. In that case, of course, that it becomes impossible to perform. So in that case, it would be voidable. Legality, contracts to the contrary to statutes. We talked about that last week, right? Contracts to commit a crime are not valid contracts. Usury is illegal interest rate. Charging an illegal interest rate is considered not a valid contract. That's the subject matter. Gambling in most states is illegal. Licensing statutes. If you are hiring somebody to do work on your house, such as electrical work, and you knowingly hire somebody unlicensed, and that person doesn't do the job right, and something happens to your house, you cannot sue them based on contract law, because as far as the law is concerned, there was no contract, because it was illegal to go into contract with somebody who doesn't have a license where the law requires you to have a license. Now, if you didn't know that person didn't have a license, that might not be an excuse. In a way, you're responsible to ensure that, but if the person pretended to have a license, now that becomes fraudulent misrepresentation. Maybe they produced a fake license. Maybe they were just so convincing and said, yes, this is my license number, without showing anything, right? That's misrepresentation. In that case, you can sue not based on contract law, but based on misrepresentation. Diego?
So would that be a different part of the law, or
Yes.
a different proceeding?
It would be fraudulent misrepresentation, but you can still successfully sue them. More contracts against the public policy, right? Restraints of trades, covenants not to compete. So it's illegal in the United States for two competitors to decide we're not going to compete. We're going to charge the same price no matter what. That's illegal, right? It's against antitrust laws. Right. So that would be ongoing business, contractual promise of one party to refrain from conducting similar business of a certain time and within a specific geographic area. In a franchise situation, that's possible, right? Because now you have a contract and the contract says we're not going to open another franchise in this geographic area. But other than that, if you say you're not going to compete with your competitor, that would be a covenant not to compete. Covenant not to compete in employment contracts. Contracts between employer and employee to state the terms of employment. I'm not going to go through this example, but I'm just going to explain. So sometimes an employer will tell you, if we hire you, you promise to not work for the competition if you leave the company. In California, an employer can't do that. In many states, they can't do that. Sometimes in some states they can, but it's very, very restrictive. Only for a certain period of time. It has to be a direct competitor and things like that. Yes.
There's this contract I signed for work that states you can't open a restaurant from 25 miles, within 25 miles of that restaurant. I think it's
They would probably have a hard time enforcing that.
Yeah.
Yeah. You can't make that a condition of employment, saying you're demanding the employee will never compete. That would restrict business, right? That would restrict entrepreneurship, right? A lot of people go work somewhere and learn the trade, and then they open a business on their own. That's a very common thing to do. So they would have a hard time. They can ask for you to sign anything, and you can sign it, but they would have a hard time enforcing it. Diego?
What about clauses about second employments, like not having a second job or having a second source of income? Not second source of income, but second.
Second job, probably not.
Okay.
But what if it's in the same scope?
If it's a competitor, they could, while you're working, if it's a competitor, yeah, they probably could say.
Because I used to work for H&R Block a while back as a receptionist, and they said that I couldn't work for another tax office.
Yeah, if it's direct competition, they probably can, because now there's this problem with trade secrets companies have, and they don't want the competition to know about it and things like that, and you know, when you're an employee of a company, you have some kind of fiduciary duty towards your employer and your employer towards you as well, right? It's a trusting relationship, right? Yes, Shannon.
So I used to work for like a swim company and I was told in their contract that a coworker and all other coworkers in the contract really that I couldn't work for another swim company for about another year. Except I didn't leave, they fired me. I wonder if that would still be in place, like if a company fires someone but in a contract.
That's, they probably wouldn't be able to enforce it either way, so a year is a long time. So you're a specialist, you're doing swim lessons, swim training or something like that, you work for the company and maybe you leave because you know, found a better paying job, or you moved to a different town and, or next door, neighborhood, that's easier for you, or they fired you, they wouldn't be, they're very likely not gonna be able to enforce that, right? And in terms of firing, they could ask you to sign that in the contract, but again, what you sign and what an employer can enforce are two different things. Enforcement problems, of course, you have to be able to enforce that. Reformation is a court-ordered correction of a written contract to reflect the true intentions of the parties. So yes, we did something, this is really kind of against the rules and this doesn't work, we didn't really mean it, let's rewrite this, right? The court might order for you to rewrite it. Unconscionable or grossly unfair contracts, right, are against public policy. There's procedural unconscionability when the terms are so complicated and so hard to understand, right? And there's also substantive unconscionability, overly harsh or one-sided contracts. And sometimes employment contracts are that, right? Very one-sided. So those would, could be deemed contracts that are against public policy. Exculpatory clause is complete relief of liability. So it releases a contractual party from liability in the event of monetary or physical injury, no matter who is at fault. That often violates public policy. You know, if you hire an employee, you can't say, oh, if you get hurt on your job, you can never sue us, or things like that. It's very extreme, right? But that's an example. Sometimes they will enforce it, right? Sometimes you sign like release of liability waivers, things like that, because you're engaging in dangerous sports activities or that's something. Diego?
Does that fall under the like release
Of
for
liability.
liability for severance?
For
Like-
what?
Like sometimes when you take your severance, you have to like sign release forms and things
Oh.
like that.
When you receive severance pay from the company, whatever the contract says is enforceable, because now you're getting paid for it. You remember in the contract, consideration is also you're giving up a right that you previously had. So if you previously had a right to work for any company you want, but the company lays you off and says, we'll give you 1 year severance pay, but you cannot work for the competition for 1 year. You better hold that. Promise, right? Yeah. Because there is something in exchange, because you don't have to accept the severance pay. You can go work for the company, but you do that in exchange for it.
Yeah.
Does that answer your question?
Yeah.
Okay. Mistakes can be made, right? There are unilateral and bilateral mistakes. Unilateral mistakes is when one party to a contract is mistaken to a material fact. What is a material fact? Numbers, yeah, something you can measure, dollar amount or quantity of products or something like that, right? A bilateral mistake is a mistake that occurs when both parties are mistaking about the same material fact. I think this one was, I'm not gonna go into the detail, but I think it was about the property and the property lines. Where the actual legal property lines were located. Does anybody recall that or? But both of them are thinking we're buying and selling this property, but it really was actually that property. Or sometimes it could be, mistakes made in the written part of the contract that nobody realized that they made a mistake. Fraudulent misrepresentation, I mentioned it a little bit ago. Typically, fraud involves a misrepresentation of a material fact. If I'm selling a 14-karat gold watch and I say it's an 18-karat gold watch, that's a material fact I'm misrepresenting, right? There must be an intent to deceive. I'm intending to deceive that person because I know if I say it's 18-karat, they're going to give me more money. And the innocent party must justifiably rely on the misrepresentation. I am a watch selling store. And a customer can reasonably rely and assume that I'm going to tell the truth, right? So they rely on what I say. If you go to buy a car to a car dealer, you have the right to assume that they're going to tell you the truth. Diego?
Does the level of knowledge of the innocent party impact whether they can sue? So like, say you're buying a watch from a watch store, but you're like a professional in that industry as well.
If the party lied about it, yes.
If the party lied about it.
If they lied about it, most likely, I can say, well, yeah, I lied about it, but I thought he would know that I'm lying. Right, that would not be, that wouldn't look good in front of the judge. I'll just try it, maybe he won't notice, something like that, right, yeah.
I'm sure people have that worse.
Yeah. So anyway, I'm gonna skip the next couple of bullets and then go on. So fraudulent misrepresentation, there has to be an intent to deceive. Lying on the resume is fraudulent misrepresentation. What could be a lie on the resume? Give me an example of what a lie on the resume might be.
I can say that I worked somewhere.
But you never worked there. Yeah, lying about work experience. Yes, Diego.
An old coworker of someone I know lied and said they were a senior manager, and they were a sole contributor. They had never managed anyone in that company.
Yeah.
So they didn't have a team, but they said they were a senior manager.
Yes, so that's again lying about work experience, lying about jobs they didn't have and positions titles they didn't hold, right? Yes.
Some people could even lie about their name, like it's not legally changed, but then they'll put a different name that they don't actually go by.
Yes. Changing your name, but when you sue somebody, you also have to sue for damages. What kind of damages could that have to the hiring company?
So like, let's say there was someone that did really good at this job and that person like got a ton of promotions and that person stole their name.
Oh, you mean like using somebody else's identity? Oh, absolutely, yes, definitely, that's fraudulent misrepresentation. And lying about your degree, saying you have a degree and you don't have, right? Now you can use nice big words when you write about your job duties and things like that, instead of saying, I ran the cash register, you could say, I managed the daily cash flow or something like that, but, you don't lie about things. You just use big words, yeah.
Is there like a little bit of tolerance, for example, like if you have like an international degree and things like that, and you're coming into the US and you're like, oh, this seems to be the equivalent of this, and then later it turns out to be like not necessarily the fact, but at the time you thought it was true.
You actually put the degree on your resume that you have. You don't compare it to a US degree. If you have and education is different, but you put the university where you graduated from and you put the name of the degree. right? You can't say, well, I got this bachelor's degree in this country, it's really equivalent to a master's degree here. You can't do that, right? There's actually, you know, in education and academia, there's comparisons between what constitutes as what. Even with your courses, when you transfer to four-year universities, which course counts as what course, right? They don't even have the same course numbers, not even the same names, how it transfers. And academia is very strict with stuff like that.
Just sometimes on like job applications and things like that, they don't have, especially if they're US centered, they don't have those options. Like if you have like, for example, I have like a diploma of higher education from the UK.
Mhm.
Nobody knows what that means here.
Well, then you can explain it, yeah.
Yeah, but like
Yeah, but
sometimes
you
they don't
can't.
have other options, you know, like they just have like, do you have an associate's or a bachelor's or master's? You know, it's like,
You can get your degree translated.
Yes.
yeah,
yeah,
I
and
don't think
that's
they have
how
a
it-
degree
yeah.
translated.
And you can always put that in the cover letter too.
No, I meant just like on like the.
On the
job
application,
itself,
but most of the time they will ask for a cover letter and then you
you
can
know,
mention that, yeah.
Like, for example, like a notary public here and a notario
Yes.
público in a different country
Yes.
has more, I guess, more towards like legal lawyer type of
Yeah,
document.
it-
Yeah.
So when you take like for myself, I took the notary course, we're not allowed to say I'm a notary public in Spanish because in a different country is a more, yeah.
Good question, though. Undue influence is persuasion that is less than actual force, but more than advice and that induces a person according to the will of the purpose of the dominating party. Sometimes people just have more dominance over another person, and they do that and put undue influence and try to convince somebody to sign a contract, right? That could be unenforceable. Duress is both defense or enforcement, most of the time defense to a contract. And a ground to rescission of a contract if somebody forces you to sign a contract, right? Next topic is the writing requirement, very important. This will also be on your paper next week. There will be a question whether your contract has to be in writing or not. And we're going to go by what we're learning in this class and in this textbook. There are other things and states require this and that, and some cities you have to do this, doesn't matter. We're gonna go by this, right? So, writing requirements, contracts involving interest in land. If you're buying or selling property, those contracts have to be in writing. Contracts that cannot meet their terms within 1 year from the date of formation. So if I'm signing up for a streaming service for 2 years, that has to be in writing. Right? Collateral or secondary contracts such as promises to answer for the debt or duty of another. So co-signing loans. This is also why when a minor enters into contract and the parent signs, they ask for that in writing because the parent promises to answer for their child, right? Yeah. Promises in consideration of marriage, simply saying I do is not enough legal. You have to sign it. And under the Uniform Commercial Code, contracts for the sales of goods, not services, for the sales of goods that are at least $500 or more. So yes.
Would a cosign instantly affect your score, or would it just if the person doesn't meet the payments?
Cosign probably doesn't affect your score, but it depends. If they run your credit report, like my daughter bought a car and you know, I bought it with her so she can get better loan terms. So in that case, yes, it is on my credit report as well. But if you're signing for your child to do a gym membership, that's not gonna show up. If you're co-signing an apartment lease, that's not going to show up. But if it's a purchase of something
But
big.
for someone to get like a loan,
You know, that's a good question, probably, because they're also going to run your credit report, because now it could be that you owe that money, right? That's a good question.
if that person doesn't pay, I'll
Then you
owe it.
owe the money, yeah. Oh, always think twice, 3, 4, 5 times before you co-sign somebody's loan, right? Yes. Diego?
So that's like number 3 specifically for co-signing, not for like if I take out a credit card and it's an agreement for like promises to answer to any debt I might accrue on that card.
No, that is your card. It does,
Okay.
there's no cosigner.
So by this, like, by these criteria, credit card agreement doesn't mean writing requirements, or?
Good question. Does a credit card agreement need a writing requirement?
It doesn't, at least from my.
Justin?
I actually went to Chase Bank recently for your assignment asking them about the contract. They actually don't give you a contract, it's a disclosure. You don't ever sign for a credit card.
You don't.
Mhm.
Yeah, technically it doesn't have to be in writing.
Okay.
Yeah.
Interesting.
All right, one other thing, by the way. They have to give you information though, they have to inform you, right? So writing requirement also means, I mean, technically you could go, of course, credit cards all have writing. Written documents, the disclosure is in writing too, right, in terms and conditions, or it's online somewhere. Writing requirement doesn't mean you have to physically take a pen and sign it. It could be you clicking I agree on a website. That's all. That means there is a document somewhere that you can look for the terms, that you have been presented before you signed it, or before you said I agree, or before you submitted this or that, right? So that's in Chase's case, right? So there is a written contract with Chase, of course, right? There's just no wet signature.
So we can say, like, in terms of writing requirement, it doesn't require an official signing, but because of the complexity of terms and conditions, they are outlining it and to cover themselves in transparency.
So the writing requirement simply means there's a document somewhere, whether it's digital or printed, doesn't matter. There's a document somewhere that you had access to before you agreed.
Mhm.
And that you hopefully all have access to for our assignment.
And I actually get you when you're in your ATM and they're like, do you want to activate this? Do you want to activate?
Oh,
All you
really?
gotta do is like click
No,
on it
no,
and
no,
it'll
always say,
activate it,
yeah. Oh, we talked about, okay, we talked about this already. I already talked ahead of time. Yeah, so I do that sometimes, I talk ahead of my cloud, so I can just stop the slides now since I don't want to repeat myself. Let me go ahead and stop the recording.